I'm Drew Stevenson, and this is for my administrative law class. This is a kind of a quick introduction to our unit on agency rulemaking. We're going to cover some of the procedures under the Administrative Procedures Act for promulgating new rules and regulations, and look at how the courts respond when the agency is doing this or and trying to do it. So let's dive in. Let's talk about the general framework of the APA, because when we talk about agency rulemaking in this chapter, we're going to often be looking at whether the agency is basically following the flow chart or the procedure set forth and stipulated in the APA. So we can conceptually divide the structure of what the APA requires into four grids, or think of it as four categories of things that agencies do. Basically, two types of adjudication and two types of rulemaking. So the two types of adjudication are a formal adjudication and informal adjudication, and these are governed by different sections of the APA. And there are two types of agency rulemaking: formal agency rulemaking and informal agency rulemaking. Again, they are also governed by different sections of the Administrative Procedure Act. So let's just talk about these quickly. In my course, the previous unit was on agency adjudication and administrative law judges and so forth, so this should be a little bit of review. Under formal adjudication, we have a trial-like proceeding at the agency level, and it's to resolve an individual's case. There's usually an administrative law judge. Often they'll be wearing a judge's robe in the hearing room, and the hearing will be held on the record. In other words, there will be transcripts and a final written opinion of the judge's decision. There will be exhibits taken into evidence, a lot of times oral testimony, parties represented by counsel, and so forth. All of this formal adjudication is governed by APA sections 554 through 558, where it sets forth the kind of duties and responsibilities of administrative law judges, the types of notice that has to be given to the parties, and so on. So what's informal agency adjudication? Well, technically, under the APA, it's all the other types of individual decisions that the administrative agency might make, like granting or revoking permits or licenses. You're camping in a national park, and a forest ranger comes up and says, you're not allowed to have a campsite in this part of the park. You need to move your campsite. Technically, that's under the APA. That's an informal adjudication. A welfare revocation hearing, if it's not formal adjudication, which would have to almost always have to have been required by the agency's enabling statute, then we're going to have what we talked about as sort of a due process or fair hearing, but it's very informal. It will be just enough to satisfy the requirements of constitutional due process. Now, make sure you're clear on this one point. There are no APA sections that set forth procedures for informal adjudication. The only rules about agency adjudication in the APA are for formal adjudication under sections 554 to 558. There's no real procedure set forth for informal adjudication. Now let's talk about rulemaking. For formal rulemaking, all it says is you follow the same sections that you would for formal adjudication. In other words, to make this rule, the agency is going to have a trial-like proceeding with an administrative law judge, but often it's going to be one of the commissioners or a secretary or administrator of the agency. And instead of trying to resolve an individual case, they're going to be on the record and taking oral arguments and exhibits and so forth. As you can imagine, this is a pretty awkward way to make a rule. Adjudication is much better set up for resolving disputes with individual parties. But the agency might do it if Congress required them to make rules this way in their enabling statute. It's pretty rare. Informal rulemaking is much more common, and this is governed by Section 553 of the APA. We're going to be talking about that a lot more in this chapter than we are about formal rulemaking. Now, it's a bit of a misnomer. Informal rulemaking still has some formalities that have to be followed. In other words, it usually means that there's published notice of the proposed rule, and then a public comment period where people can submit comments, and then a final rule gets published in the Federal Register. Now, during the comment period, let's talk about the comments for just a moment. We're going to have comments submitted to the agency generally from three types of sources. As you'd expect, the regulated industry, whoever is going to have to follow the proposed rule or regulation, is going to have an interest in commenting on it. And very often they're going to be saying that the proposed rule goes too far. That shouldn't surprise you very much. That it's going to cost too much to comply with, and that the agency should scale it back or dial it back a little bit in the final version. Now, keep in mind that the regulated industry is usually going to submit pretty sophisticated comments, lengthy comments. They're going to hire their own scientific or safety experts and economists to do studies and projections. They'll hire lawyers, elite lawyers often, to draft the official comments that they submit to the agency. So the agency is going to receive high-level comments, and often critical, from the regulated industry, and some of these could come from individual companies. Very often they come from an industry trade association. They'll also get comments from the other side, predictably. These are citizen activist groups or public interest nonprofits that are basically kind of opposed to the regulated industry. So if you think of the fossil fuel industry, we might have environmental groups, net zero groups, and climate activists, and so forth on the other side. And very often their comments that they submit when there's a proposed rule will argue that the rule doesn't go far enough, that the agency is selling out to the regulated industry, that the agency should be demanding more and trying to fix more problems. Now, larger nonprofits or advocacy groups will also submit pretty sophisticated comments. They're going to have lawyers, and sometimes elite lawyers, draft those comments, and they may have their own studies from economists and sociologists or public safety people and so forth, that basically arguing that the proposed rule needs to be fixed. And typically, the advocacy groups are going to say that the rule should go a little further. And then our third category, we're going to have some comments submitted by just average citizens, individuals. These range from thoughtful to the type of things that you would see posted on social media, especially on X or Twitter. And some of it's pretty crazy conspiracy theories or just uninformed slogans, things people have picked up from memes, and so on. Yes, so there are thousands and thousands of comments basically saying the agency shouldn't exist because it's unconstitutional or something, and the person often kind of betrays that they don't really know what the rule is about, they don't understand the legal system, and so forth. And a lot of these people are copying and pasting a blurb from some activist newsletter or blog or an email that they got. Now, what does the agency do? When the comment period closes, they sort through all the comments and they publish the final rule. And the final rule is going to have the force of law. When they publish the final rule, they're going to have to respond to the comments. Now, for the serious comments that they receive from the regulated industry or from advocacy groups, that, as I said, serious comments, the agency doesn't have to follow their suggestions, but they have to explain why they're not. They have to say, we received comments saying that the rule goes too far for this and this and this reason. We disagree. We did our own studies. We have our own scientists and economists and so forth who have different findings. So we're following different, or we considered this alternative and we decided that it's not the best alternative. And the same with the serious suggestions that come from advocacy groups. For the sort of useless suggestions, that is what most of what comes from private individuals, agencies may say something like, we received 50,000 comments saying basically that they don't like the rule, that we shouldn't be regulating this area at all, and so forth. And whether they like it or not, we have a statutory mandate to do so. Just so you understand, when we say public comment, this is what we're talking about. We have generally the comments are going to be coming from three types of sources. The agency will have to give some serious responses to serious comments, and then can kind of give somewhat dismissive comments to the unserious comments. Okay, keep in mind that if the agency skips procedural steps with informal rulemaking, that can be grounds for challenging the rule. This is very important for understanding the cases that we read for my course. In other words, the kind of teeth of the APA is that if agencies skip a couple of steps or cut corners, even if it's a great rule, the court likes the rule on the merits, a court could invalidate the rule and send the agency back to start over for not following the proper procedures. Remember that it's going to take months to publish a new rule, to draft it, publish it, have a public comment period, and then eventually publish a final rule. It could end up taking actually a year and a half or 2 years. And by that point, we could have a different party in the White House that is decided not to pursue this type of regulatory activity or wants to take a different direction. So to some extent, there is a little bit of a race against the clock for the agency to see what they can do, and they have an incentive to try to promulgate something that will hold up in court, because even if they get a do-over when they lose in court, they may not have time before they kind of have new people in charge of the agency for whom this rule was not a priority. It's important to keep in mind that the Administrative Procedure Act is purely a procedural statute. It doesn't have substantive provisions. So for law students, you may want to think of it as sort of analogous to the federal rules of civil procedure, except that it codifies some procedures for regulatory agencies to follow. So the APA sets forth procedural rules that agencies have to follow when they make new regulations, or when they adjudicate claims brought under their regulations, or maybe challenges from someone to, say, a license revocation or something like that. And when the agency brings enforcement actions for violations of their regulation, if the agency is doing the first step of adjudicating that through an administrative law judge, that will have to follow the procedures in the APA. But there is nothing in the APA, the Administrative Procedure Act, that says what policies are good or bad, what counts as too much regulation, whether agencies should be more conservative or more liberal or anything like that. The APA is purely procedural rules.
It's just procedural, right?
It's just procedural.
It's just procedural.
It's just procedure.
Another important thing to keep in mind when we're talking about agency rules and regulations is that regulations often look like statutes. A lot of them are codified in the Code of Federal Regulations, or the CFR. And their format and structure will look a lot like statutes. In other words, they're topically arranged with numbered and lettered subsections and sections and so forth. And so they're, in terms of sort of the genre or structure, they're not sonnets, they're not song lyrics. They are going to look and be written a lot like statutes in the same form. Also keep in mind that regulations from agencies, if they're authorized by statute, they have the force of law. In other words, they are just as enforceable against violators as a statute would be. On the other hand, with regulations, courts are more likely to look at whether proper procedure was followed by the agency in promulgating the regulation, whereas they don't really look at congressional procedures for deciding the validity or legitimacy of a statute that's been enacted. They'll also kind of scrutinize the courts whether an agency was acting within its statutory purview, and generally the Constitution makes clear that Congress always has the authority to make laws as long as those laws don't violate some civil rights provision or separation of powers provision in the rest of the Constitution.
We sent it back in February on account of new regulations.
As scientists, we have to circumvent these ridiculous bureaucratic regulations, no?
A quick point of terminology. Statutes are enacted by Congress or the legislature, but regulations and rules are promulgated. That's the more precise legal term, or we may say published. So it's generally incorrect to say that a regulation or an agency rule was enacted by the agency. Enacting is something Congress does or the legislature does with laws. The agency will publish or promulgate a rule or a regulation. So wrapping up here, that's our basic framework for the Administrative Procedure Act and what happens when agencies are engaged in agency rulemaking. If you receive an adverse decision, if a party receives an adverse decision, they can seek federal judicial review in the courts. Of course, subject to some conditions like standing and filing within certain deadlines and so on. Now, I'm going to have a separate video where I talk about agency guidance documents that don't have to follow notice and comment rulemaking, so stay tuned for that.